Good morning, everyone. Welcome to the POR Working Group meeting for Wednesday, November 10th, 2021. One of the things today we're going to go through is the calendar for the rest of this group. What I'm going to do is just show you a proposal. We can bring it up later when we talk about the calendar, but this is just some possibilities. I'll share that right now. What this does is show that we have quite a short deadline. The report to the legislature is due on January 15th. It's a Saturday, and I think we'd much prefer to get it there on Friday than on Saturday. So we can go back to this screen, but just to give you a taste of what the future calendar might look like, but that's a decision for the group today. Okay. Were there any opening remarks you wanted to make, Olivia? Okay. And then our chairs. Angie.
I don't really have anything in particular. I know that Stacy has something that she wants to share with the group, and we were going to talk about, I think she wanted to go through also the data practices table and talk about that stuff. And then I was thinking it might make sense, I don't know what else is on the agenda, but it might make sense to go through kind of that list of issues and just see where we're at on each issue at this point.
Okay. Sheriff Heck.
I'd second what Angie said. I don't have anything else to add.
Okay. Stacy.
Yeah, so I would like to, I sent to Mark and Olivia a PowerPoint that we received from, let me just be precise here in my words.
It was Alpha something.
Yep, from Alpha Emergence Behavioral Health, Rhonda Dish and Brenda Fry, who I believe will be on the call today.
Okay. Okay. And how did you want to share that?
Stacy's muted.
Yeah, sorry, I accidentally muted myself. I just wanted to just let the working group know that we received a deck with some information, some of which we've heard before, but this is coming from the sexual offender treatment providers and some things that they're seeing from the treatment side and interactions with people convicted of predatory offenses and how the registry is impacting the treatment and successful integration into society There's a discussion that I would just note in this PowerPoint that talks about protective factors for individuals and how treatment providers, or at least for Alpha Emergence, who put together the deck, are seeing that the protective factors that help folks reintegrate and be successful in not reoffending are impacted by certain aspects of the registry. So we can just, what I'd like to do is just have that as the materials that the working group received. We could share them on the website, but so that it is part of the materials that the working group did receive. I think if we put it up on the website and so working group members can access it and look at it for consideration, and have it as a resource that can be drawn upon if appropriate in the preparation of our final report to the legislature. So I would just introduce that document as, in lieu of having someone come speak on it, we would introduce the PowerPoint just as a information that the working group received. We can talk about some of that if folks want to hear about it, but I think probably just putting it on the website and making it available. Maybe Mark, you could just, or Olivia, we could just share the front page of it so folks can just kind of see the what it looks like, and if working group members would like more information of the perspective from sexual offender treatment providers, and in this case specifically Alpha, they can access this information at the website. Are co-chairs comfortable with that approach?
That's fine with me.
So you see the front page of what it looks like,
Yep.
and it'll be listed as, we'll list it as sex offender registry and residency restrictions from Alpha Emergence. Okay.
So that's all I have for the group this morning, just making sure that that's part of our, the information that we've received. And again, in lieu of having people talk about that, to the extent that there might be some repetition, opting for a deck instead.
Okay. And then Angie, you wanted to look at just some of those subject areas we've covered in the subgroups and in the larger group meetings.
Yeah, I don't know if we want to do the data stuff first or that first. I don't really care.
Okay.
Stacy, preference? Or Troy?
I have no preference.
So which should we go with?
That's fine to do the subject matter. If you have the list handy somewhere, I know Stacy
Yeah.
sent it to me yesterday.
Yeah. So here's that list of areas. They're not in any specific order, but have been pulled from some of the discussion that has gone on.
Okay, so, and just for the group to know, the chairs met yesterday and we're trying to get together with Olivia and Mark, kind of one document that has all of the kind of possible proposed legislative changes in one place, so that we can, kind of discuss them in one place at the next meetings. So with these first issues, the crimes of sexual nature, such as false imprisonment, or not as a sexual nature, such as false imprisonment and kidnapping, and the same sort of circumstances language Troy drafted some language that requires a conviction for false imprisonment. And he also drafted some language for false imprisonment itself that exempts either domestic or ends in the crim sex. I think when we talked about it, we thought that the exemption of the domestic made more sense if that statute was changed. But that maybe the false imprisonment not requiring sensitive circumstances dealt with that issue. And I think the general consensus was that kidnapping should just say as it is. Does anyone else have anything to add on those issues? Okay, Mark, do you want to go down then to the kind of next area?
Okay, here,
So
I'll
we'll have that language. We'll have some language on those issues, or we already have in some of the subgroups, and we'll get that together in one document for people to look at and see. And ultimately, Mark and Olivia will survey the group as a whole to see kind of what the majority and minority viewpoints are in these issues.
Representative O'Neill.
Yeah, I was just gonna say, both Kelly Miller and I said the same thing. We could not hear hardly anything that Angela had to say, and this is super important because we're kind of winding down to what's going to be in the report and not. And yeah, we just couldn't hear you, and it's hard to try to read that and then distinguish what you're trying to say. So I think both of us kind of lost it, and you really want us to know what you just said. I guarantee you.
Okay, is that better? I'm leaning toward my computer. Is that any better, or is it still not good?
It's a little bit distorted, but we can hear better.
Okay, so what I was saying, Representative O'Neill, is that for these first issues, the crimes of a sexual nature, or not of a sexual nature, I should say, such as false imprisonment and kidnapping, and the same set of circumstances language. My understanding of kind of as a whole, what that's resulted in is there's some proposed language to require a conviction for false imprisonment itself, not, so that wouldn't fall under the same set of circumstances. And there's some alternative language, so that language would be in 243-166, just taking false imprisonment out of the same set of circumstances. There was some alternative language that Troy drafted before we talked about the false imprisonment conviction, and that was, he suggested some language that could go to change the false imprisonment crime itself and break it down, either separating out the crime of false imprisonment in a domestic situation, and then not requiring registration for that, or adding in that they have to be charged with a registration offense along with the false imprisonment. Didn't make a lot of sense to me because that seemed redundant, because those sex offenses are already going to require registration. So I think we kind of landed on changing the registration statute and taking false imprisonment out of same set of circumstances, probably most directly accomplished what we were trying to do. And possibly maybe doing that and separating the domestic out of false imprisonment. I don't know that you need to do both, but and then I also said that we're trying to get all of these kind of possible or suggested language changes into one place. And then for this group, we'll do some kind of survey to figure out which of these suggestions are the majority view of this group and the minority view, so that in the report, we can let the legislature know that. Were you able to hear me for that? So this
Okay,
next part
Patty?
about, oh, go ahead.
Patty?
I
Patty.
just have a question about, I know this has probably been discussed, and forgive me for my short memory, but kidnapping of a child is always, almost always a sexual crime. So just taking out that word doesn't sit well with me. I know that there might be gang-related kidnapping, or so, is that what the discussion was? It might be for drugs or something else, but I think that we should specify that, I don't know.
We weren't,
No.
the language does not take out kidnapping, Patty. It only takes out false imprisonment. So for false imprisonment, it requires a conviction for false imprisonment itself. You couldn't have to register for a conviction out of the same set of circumstances as false imprisonment. The kidnapping was still in there for both.
But it says false imprisonment and kidnapping, so I'm confused. I'm
No.
sorry.
Right, that's just the issue. Mark had summarized the issues we've been talking about, and we landed on leaving kidnapping in, but
Okay.
separating false imprisonment out for same set of circumstances purposes.
Okay, thank you.
It's a good clarification. Stacy?
Yeah, Patty, as you know, the original statute passed in 1991 had kidnapping of a child. And we discussed kidnapping just as it's one of the non-sexual crimes that are on the registry, but recognizing, like you just said, kidnapping of a child will often involve a sex crime to follow. So, and we also did talk about kidnapping, this is for the group, kidnapping then later included adults. And so there was discussion about, well, should we take out kidnapping or keep it in just for children and take it out or separate it or limit it for adults? And then the issue was raised that kidnapping of adults that would be seen in human trafficking situations. And so we would want to just keep kidnapping in as is. And so that's where we landed. So this, just to clarify, this only is looking at false imprisonment. And the discussion of that false imprisonment and domestic assault often go hand in hand. The person accused of a crime will typically plead to a domestic assault charge, but then they're on the registry because of the false imprisonment charge, even though they weren't convicted of it.
And I can say, at least based on my review of cases, that is pretty common for same set of circumstances.
Representative O'Neill?
Thank you. So the false imprisonment, obviously, we've talked about multiple times, multiple subcommittees. I like the idea, and I'd like to just have a conversation about this if other people also agree with having it rely on a conviction and that it's not part of the same set of circumstances, but just, I'm wondering if we could talk about that. I mean, that just seems like, I don't recall that conversation that specifically come up before, but it certainly seems like a good solution. Anybody else have any thoughts about it?
Yeah, that did come up in the crimes, I think it was the crimes group. And we did draft language because of that discussion. I wasn't at the initial group, and Troy drafted the language changing the false imprisonment statutes. And then when we discussed it further among the chairs, I suggested we might accomplish the same objective, just taking false imprisonment out of the same set of circumstances. Then we drafted some language for that too. So we were going to share all of that, all of that different language. But at least my opinion was that taking the false imprisonment out was a more straightforward way to address the issue.
Okay, Katie,
I just wanted to ask, I think going off of Patty there, that top bullet mark, should it just say kidnapping and false imprisonment remain in the registration system and then just solely account for taking false imprisonment out of the same set of circumstances? I think that might clarify, because I kind of was thinking the same thing that Patty was saying there. That first statement looked like both of them were coming out, but really what everyone's saying is that false imprisonment and kidnapping will remain a registration offense, just the false imprisonment will not have the same set of circumstances apply to it. That was all I had.
okay, Sheriff Heck.
Yeah, I just wanted to say that out of the three swings I took at drafting language toward that I would also agree that Angie's concept of removing the same set of circumstances attachment to false imprisonment, but including it as a registration offense is the clearest and most eloquent way to do it, in my opinion, as well. And I also want to make sure that Angie got credit for coming up with the idea, because I think it was brilliant.
Okay. Anything more on that subject? Again, it's not a final until you see language, but
And then this next one on reinstate and retroactive provisions based on convictions for a crime against the person. Is that talking about the extensions, Mark?
no, that is when somebody expires from registration or they were never subject to registration prior and they commit a crime against the person.
So I don't think was there discussion about changing there? Did we look at the list and say that we thought that seemed fine?
Yeah, I think we discussed it. I don't know that we came to a conclusion that it seemed fine. But we decided, I think based on what was on our plate at the time, that we would tackle just the, for now, we would address just the restart for 10 years in the case of imprisonment resulting from a conviction of any crime. So I mean, we didn't dive into the substance of the reinstatement or the retroactivity that results from a later crime against the person. So just to be clear, I wouldn't say that we're fine with that. I think we just didn't look at it substantively because we were really focused more on the extension of 10 based on imprisonment from a conviction of any, from any conviction.
And Mark, do you have that listed as a separate issue or no? The extension.
What was that? Yes, it is a separate. Yep.
Okay.
Is it
Okay,
on
so
this
this
list?
is,
Mark, is it on this list somewhere?
Yeah, it's
Okay.
on this. Again, this list is actually pulled from the discussion. It's not in any order of top issues of discussion, which we could
so,
do that. So,
well, I was gonna say, as long as we're talking about this, then we might as well talk about that. So we
Okay.
did,
here. So here's that
okay. So-
subject of extensions.
Okay, so on that issue, we talked about limiting extensions for reincarcerations or new convictions to either registration offenses under 243-166 1B or crimes against the person offenses. We took out the two possession of firearms parts of crimes against the person. And we added terroristic threats and violation of no contact order. But I had suggested we could do alternative language. One, that leaves the terroristic threats and violations of no contact order in, as those require extensions, and one that does it just for the other crime, for the actual crimes against the persons listed 243-167. So I drafted, we did like a subgroup. I drafted some language, and Chris and Stacy have given edit suggestions. So we haven't gotten the final language to Mark and Olivia yet with the changes, but we are working on some language that would do that in a couple ways. And then what was the issue, Stacy, that came up today that I said, oh, what we should do with failure to register convictions and that extension, and whether there should be any changes as far as that goes. Right now, the statute allows a 5-year extension for failure to register, for non-compliance.
Right, that's 1B. Subdivision 6, 1B. And Chris, is Chris on today? In any event, we haven't we've touched on it, but we haven't discussed it in substantively very much on what we might want to do there. So I would just say that's an open issue.
And that's something maybe, I know we don't have a lot of subgroups left, but we could touch on that in that subgroup
Yep.
Next week. Okay, Mark, if you want, oh, go ahead. Representative O'Neill wants to talk.
Yeah,
Yes,
just really quickly, just because of the history of how we arrived at extending the registry based on noncompliance. I think that it's going to be problematic at the legislature. I don't know if Senator Ingebrigtsen is here, but I have a hard time believing that that will make it through the Senate. So just because of the history. So, I've talked about the history multiple times, that it started in 2000 and it was extended because the compliance rate was 36%. And so they increased the penalty. And now we have close to 90%, I think is what the BCA said last time we talked about this, a compliance rate. If we want to talk about maybe making it slightly easier for those that are homeless, that seems to be a big issue. I know that some of those things I think were fixed in Katie's law, but I'm just going to let you know that removing the extension based on non-compliance is probably not going to pass the Senate. I don't know if Senator Ingebrigtsen is here and wants to speak to that, but or maybe Sheriff Heck wants to talk about it.
well, just a clarification there. This is about re-triggering the registration period, not about whether it's a felony conviction or whether there's a 5-year extension for failure. Because with a failure to register, it both re-triggers and adds another 5 years. So it becomes a 15-year registration period. That's not what's covered in this.
Okay.
Yeah, and we didn't include failure to register in the amended language on extensions. So the way it, like, if just that part were changed, right now, the 5-year extension for failure to register would still be part of the statute. And that's what we were talking about. Is there, or should there be any recommendation as far as that is concerned? One thing I would note about that is it does allow the BCA to basically extend for 5 years for non-compliance. Anytime, I think from a practical standpoint, Katie can correct me if this is wrong, that only happens if somebody's actually convicted for failure to register. Maybe it would make sense to clarify, or to make that part of the statute require the conviction for that 5-year extension. But right now, as it stands, it wouldn't trigger with the proposed changes where we include only the crimes against the person. It wouldn't, the failure to register conviction then wouldn't trigger that, or the incarceration for that wouldn't trigger the 10 or 15 years. It would just trigger 5 years. Is that right, Katie?
Yep. Yep. Do you have an unmute button?
Yep, it's there, sorry. Yeah, I want to take a step back even and go back to Mark when you said that it would restart for 15 years. I want to clarify that they actually have to serve the time and not have the time stayed to go to 15 years. And Angie, you are correct in that the statute says that any period of non-compliance could, that the Bureau may restart or add 5 years to the registration period. My predecessors, going back to the beginning, even have always required that conviction. Administratively, it would be a nightmare because somebody might have to have returned their verification. Let's say it was due yesterday, it comes in today. Would we restart their period just because they hit that non-compliance for 24 hours? Logistically, that's a nightmare. But if the group wants to do it, if we want to follow the exact way of the law, that would be it. So I would be with Angie. If any change comes of it, you could put in that it would require the conviction. But those two clarifications, the 15 years would only happen if they serve time or are given credit for time served. Otherwise, it would just be adding the 5 years on top if they stay that sentence.
Stacy.
Yeah, so to Representative O'Neill's comment, there's been this, this reference to a 30-some% compliance rate. And then was that Hennepin County only, or was that statewide?
Yeah, so I need to go back and listen to the tape. I can tell you that the officer that came was a Minneapolis police officer. I believe he was representing the state though, not just Minneapolis PD. But I will have to go back and listen to the tape to see if that was a number just for Hennepin County or if that was statewide.
Okay, so I would I think that might be an important point to know that whether that was a statewide compliance rate or if it was a Hennepin County. So just so we're careful about comparing compliance rates. And so, and the change in penalty for a failure to register conviction, that is what you believe is driving the compliance, the higher compliance rate, whatever the differential is. You believe that it's the felony, the prospect of a felony charge and conviction that's driving the compliance rate. I just want to understand where we're going to have some pushback from the legislature.
So to that point, I'm letting you know that those in the Senate will frame it that way. I've done this long enough to know that's what they're going to say. And it's going to be hard to overcome that. So whether that's accurate or not, unfortunately, we don't have really data to support it either way. And honestly, I hope this is on the list that we can actually request that the legislature fund some changes to the database so that we can pull out some more granular information, which right now we obviously cannot. But in any case, I'm just letting you know that on the Senate side, because of that history, and the person that was most interested and active in that hearing in 2000 is still on the Judiciary Committee now in the Senate. And he happens to be my senator out here. So yeah, I just think it's going to be to change it. that conversation will come back up. Now, we're not saying, well, let's just eliminate the felony, failure to register, but any changes, they'll go back to the 2000 conversation.
Okay, yeah, that's totally fair, and I appreciate the candor in terms of there's a narrative, whether there's actually data to support the narrative is a different issue. Because I am interested in that compliance rate and having more understanding of why it changed, what compliance rate are we talking about? Was it Hennepin or statewide? And then if there was a change from, I think it was gross to felony,
Yes.
What was the trajectory of compliance? Do we know that the two are actually tied? We think they are, but do we actually know if they are? Because if it turns out that they aren't, then we would want to understand, well, what is driving a higher compliance rate? Because we want compliance. And if it's not the felony, or if it's not the reason, whatever it is, we want to understand, why do people want to comply? And that seems like an important information. So I appreciate that you would be supporting, a request of the legislature to understand and gather data that helps us evaluate why compliance is happening at a higher rate.
Yes, and I think we also need to take into account the full changes that happened with Katie's Law. There were other changes also with homeless and specifics. So I know the BCA went into great detail about what that change was, but it could be that going from a gross misdemeanor to a felony had no impact. We don't know. We just don't have the data to say one way or the other, because there were also other changes in statute at that same time. I'm just letting you know that we're going to have to get our ducks in a row if you want something there to change with supportive information and data. And we just simply I don't think we have it because the database just doesn't provide it the way it's structured right now. So one of the great recommendations I think should be to transform the database into something that we can actually pull data from and answer those types of questions. We're going to have this conversation many, many times. I know Representative Mueller and I had a conversation offline yesterday, and it's problematic that we don't have good data, and no fault of the BCA at all. It's just the way that the database was built, and now we can't extract what we need out of it.
Sheriff Heck.
I just wanted to voice a concern I have about the concept of narrowing the registration restart to certain offenses rather than any offense that it currently sits at. And I realize this very well may be a minority opinion, but I've in the presentations I've seen now over these weeks, I can remember on at least a couple of occasions, and including that slideshow that that was just recently mentioned today, the fact that a protective factor for these folks to rehabilitate themselves is to remain crime-free. And that statement, I think, is reflected in this requirement that there be a restart if they are not crime-free. The information that I've seen hasn't specified that the person refrained from person crimes or from serious crimes, but the fact that they remain crime-free is an indicator that they are less likely to be a risk, or that is more likely that that's going to be a protective factor. So that would be the reason that I might object to this idea of changing the restart from any crime to just a select few.
Representative O'Neill.
Thank you. I'm glad Sheriff Heck said that, because something else that we discussed in several of the subgroups was that when you got somebody that is active in their addiction and not getting help, and you see that through their criminality, you see that through maybe a DWI or a DUI or some other sort of drug-related issue, then they're at a higher risk of reoffending. And so if we limit this to just crimes against the person, I think that is a dangerous precedent. And I personally would not support that, because I think that that's a dangerous thing to do, because there's so many indicators there that they are they're increasing the risk to the public if they are not sober. And so many crimes, as you know, I mean, if you just look at addiction rates in the court system, it's about 85 to 90% of those that commit criminal acts have an addiction issue. They go hand in hand oftentimes. So I think that this is, if you want to parse out the addiction type crimes, that might be helpful, but I don't know that it is, because addiction also drives other criminality. So I think this is, this would not go through the House and Senate. I think this is problematic.
Stacy.
Yeah, fair points. We have seen information that, living offense-free reduces risk for recidivism. 2 points I just want to make is they'll still be on the registry. Even if we limited that, they're going to still be on the registry. So it's not like they go off. They're just not going to be on for another 10 years. And the second thing I want to just point out is, if it's a noise ordinance or a DWI, and fair points on the DWI as well. But again, what is the actual increase in that risk? And knowing what we know about the registry, which is that that as a tool, these people on the registry, we know as in terms of investigating crimes and clearing and identifying suspects for unknown crimes, this group of people is really, is not, how do I say, they're not the likely suspects. True, they would be a suspect, and that's the point of the registry. But I think we just need to be really clear in, these things of, what is the actual risk increase, because someone does get a DWI, and I don't know that we know, it's so person specific, but to the extent that the registry is being used and to what degree to identify and clear suspects, what I've heard is that those numbers are really low. As long as there's a risk, we like to have this tool, and I understand that too from a law enforcement perspective. I certainly appreciate Representative O'Neill that this is something that you wouldn't support, and I can see the arguments for it, but I just wanted to raise those other points so that we have a complete understanding of what does it mean when someone does have a reoffense, and what is the actual increase in risk.
Chris.
Thank you, Mark. And sorry, I was jumping on late. So if this has been covered, I apologize. But I just wanted to make the point, if it already hasn't been made, that I think the crimes that are outlined in a proposed redraft to the registration period, when it would renew for another 10 years, have already been selected as being different, or apart from, as being defined as crimes against the person pursuant to 243.167. So if a person had completed a registration in another state, was no longer required to register, came to Minnesota and committed one of those crimes, they would be required to register. That's my understanding of it. So these crimes, it's already been determined by the legislature that they're a little different than any crime. So, if that's something that wants to be reconsidered, that could be. But I think the crimes against the person definition has already been considered. These crimes are separate and apart from any crime. And I think that's already been determined. So just wanted to say that.
Representative O'Neill.
Thank you. So thank you, Stacey, for pointing that out. I appreciate that. I have a couple thoughts. If you want to parse it out, maybe do a 5-year and 10-year. So Or, you know what I'm saying? So the ones that you would eliminate altogether, just reduce it to 5 and then keep the 10 with what you're saying here. Or focus on the off ramp. And so someone, if they have gotten their life together and they're sober and they're living in compliance, then the off ramp would be an option. So those are a couple of suggestions. I'm just concerned that if somebody is not sober, that their behavior and their criminality tend to not be very good.
Brian,
Just wanted to remind people about the desistance information I provided a month ago or whenever that was, related to, if we're looking at sexual recidivism, and that's the main concern here, folks that continue to commit non-sexual crimes, they're at greater risk than those that go crime-free, but there's still a reduction in their risk of committing sexual crimes. Even if they are not completely crime-free, where there's that table I presented that said, you kind of subtract 3.3 years off if they're committing other crimes. So there's a way to empirically look at that data. And if we're looking at, this gets into the off-ramp situation, but which we'll talk about soon, and we're looking at individual cases and whatever process we have for that off-ramping, we can take all that into consideration. We can say, well, they haven't committed any sex offenses for 10 years. They have committed some other crimes. That reduces their risk this amount, and take that all into consideration on an individual basis when we get to that point. But just want to make sure that brought up again, that desistance research, take that into consideration.
Janine.
Yeah, I really appreciate those comments. I would just, it does sort of feel like as we take each of these bullets that there's an interconnection between some of them. Like when we talk about the off-ramp and keeping people on, they're kind of connected. So we're kind of run into a little bit of trouble when we isolate these out. I think the conversations are really good, but I'm wondering if at some point we kind of need to say, if we move this, it's going to, or we can't address it here, maybe we could address it over here. I think like to the comment about the Senate, whenever we start something with limitations of statutory, like if we use words like that, we're going to have to be careful a little bit in the nuance when we do statutory language. And I appreciate, Mark, that this is just a bunch of bullets, that there's not in any order, but the off-ramp really does intersect with some of this conversation. That's all I just wanted to highlight.
Yep, and that's a appropriate segue into that area.
So Stacy and Brian, maybe you can talk about what's going on with that process, because I haven't been really involved in that. I think there's one other person working on that with you guys.
And Renee, yeah, but Stacy, if you want to go ahead, if you want to jump in.
Here you are, Stacy.
There we go.
There.
Yeah, so the subgroup has met 2 times, and we are looking at, we are canvassing other states for how they have modeled their petition for removal from the registry. And we are drafting, we are in the process of drafting language that we will bring to the subgroups next week that would provide for an administrative review panel modeled after the ECRC, which is the End of Confinement Review Committee, which is, for those who don't know, it's the, and Brian, if I misstate what it is, but my understanding of what it is, it's the committee that meets to assess and determine risk level to assign someone who has been convicted of a sex crime, assign risk level after they are out of confinement. And in that process, they have 5 people on the ECRC that evaluate a bunch of different factors. The off-ramp or the petition for removal process would take a page from that playbook. And so we have a list of proposed disciplines or professionals that would compose that administrative panel. And then we are looking closely at the criteria for what would qualify someone to meet the standard. And we're going to determine what the standard, we're going to propose a standard. What criteria needs to be met to establish that they should come off the registry because they have been rehabilitated and no longer pose a risk to the public. So we're fleshing out those criteria pieces, and that's where we are in the process. Included in that are for juveniles. There's two issues that, as I see it, that we're talking about for juveniles. One is, should juveniles be on the registry? And if we decide that the answer is yes, or at least some subset or some, group of juveniles, particular group of juveniles should be on the registry, and maybe some should not. Of those juveniles that are on the registry, how would the petition for removal or off-ramp, how would that process work for them? What we've seen in states, in canvassing the other states, is that juveniles are treated in many cases differently on the petition for removal than adults. And so we need to look at that. And that's, again, an important, those two, to Janine's point, which is these things intersect. If we're going to keep, if we can't come to a consensus on juveniles, or at least some group of juveniles coming off, then we will look at a petition for removal that would limit that time, so it's not a perpetual registry commitment. Brian and Renee, if you have anything to add, please do.
No, I was just going to add with the ECRC piece, Stacy, you mentioned sex offenses and for community notification purposes. As we know, though, it's anybody who is required to register. So it does include some, the false imprisonment, kidnapping, non-sex related folks that then end up in prison, and 4 to 5 months prior to release is when we have the ECRC committee itself. So just a couple little side details there, but otherwise sounded great.
Yeah, I don't have anything else to add either. You accurately provided what we're working on, so.
Yeah, I guess the one thing I would quickly add is that there is an issue of access to this petition removal that Brian and Renee and I have discussed. Who is going to be able to avail themselves of the opportunity? Because, for example, if a psychosexual is required, that costs money, and so some registrants might have resources to pay for a psychosexual and other costs related to bringing forth a petition, and some other people may not have resources to bring a petition because they can't afford a psychosexual or the other costs associated with it. And so while we recognize that there is a potential disparate impact on under-resourced individuals, what we are focused on right now is coming up with the petition for removal process, and we will then look at opportunities to have possibly funding and resources, but we don't want, at this point, we don't want the disparate impact or the possibility that there would be a disparate impact to prevent us from coming up with a petition for removal process by saying, well, only some people are going to be able to access and not everyone can afford it. That doesn't mean we shouldn't have the process devised and proposed. And then as we, move along and further understand how it will work, resources and looking at resources can be the second phase of how that would work.
Representative O'Neill.
Thank you. Thanks, Stacy and Brian, for working on this. I really like that you've patterned this off of the ECRC process. So determine the risk level. I think that's great. My only comment would be same thing I said in the method subgroup, which is you need to be really thoughtful and mindful of how many you put on, what odd numbers better. And then the vote is really important. That's something that will be very contentious potentially at the legislature, whether it's a unanimous vote, supermajority vote, a simple majority. I would recommend, knowing how the legislature will hear this, a unanimous vote is your safest bet. So now your proposal is a proposal of 5. Okay, so now you've eliminated one position. So 5 is good. I would recommend a unanimous vote, and it has the highest likelihood of success at the legislature.
Thanks for that.
Representative Moeller.
Thanks. Yeah, one thing I was considering too was how frequently can someone apply? So if they apply and denied, putting some guardrails around, do they come back a month later? Is it 6 months? Is it a year, 2, whatever it is? So I think that's important because cost is certainly going to be a factor with this. And then if someone can answer this question, so currently with the ECRC process, it's an administrative review. And then is there an appeal? If somebody doesn't like that decision, does it appeal to district court and then the Court of Appeals? I can't quite remember the order of review. Angie,
Brian.
probably knows.
Angie has her hand up. She can address, I can address it, but Angie can.
Yeah, I my heart was going kind of fast about this whole thing because we represent the DOC and ECRCs. So part of the issue or question I would have as far as seeing the entire legislation is there, whether it's majority or unanimous. So let's say the panel says, oh, you know, this person should be at the registry. Who's and maybe you've covered this and I missed it. Like, who's representing the state on that? And if there's an appeal, you know, can the state say, separate from this panel, can the BCA or the state or whatever say, well, this person, you know, we think they should still be on the registry? Or if the person's denied coming out the registry, can they appeal? And that right now, Representative Moeller goes through, at this point, they can, so let's say, so right now, risk level 2 or 3 offenders can appeal to an administrative law judge. So if the DOC says, we're giving you risk level 3, they can say, I shouldn't be a 3. They file the appeal, it goes through an administrative hearing with a judge, and then that can go by petition for cert to the Court of Appeals, which is, I mean, it always happens. So it appeals, you know, they never turn those down. So the appeal goes then from the ALJ to the Court of Appeals and then potentially to the Supreme Court. So my question, I guess, is it just this panel process that's contemplated, then that would just be what it is? Or is there any kind of further process that requires somebody from the BCA or from our office or from somewhere? Because that's obviously going to make an impact from a fiscal standpoint.
Stacy.
So on the question of how often, we will look to states, to other states who have a limit on, no, I don't think it will be, you come back next month. I think it would be there's got to be a substantial amount of time between. So one state, I think it was a year, but we'll consider that. As far as appeal, honestly, I haven't given that much thought. And would rather not think about that. But one of the questions is, does there need to be an appeal process? I mean, if it's unanimous, that yes, you can come off, right? So let's just go with the unanimous scenario. It's a unanimous vote. Petition for removal is granted. So the person or the entity, there may be some state agency who has a problem with that, right? Like they know something we don't, or the panel doesn't. And so they would want the appeal process, right? On behalf of the state. And then if the person is denied, they didn't get their 5 votes, let's say, they want to appeal it. I mean, my inclination, we'll have to take a look and see what other states have done. We haven't dug that deep into an appeal process, and so I don't know. It may be that it doesn't exist in this petition for removal, or that some states just are like, this is it. It's, you get one shot and you can come back. I don't know if that presents
So
constitutional due process issues, Angie.
Yeah,
I can,
I don't know either. That's what I'm questioning. Yes.
I can address the ECRC appeal process a bit, and Angie can correct it if I'm wrong on this, but the ECRC process imposes something extra on the person, and that's why there's an appeal process. There isn't an appeal process when somebody is asking for relief from the ECRC risk level. They actually, when they're denied, they don't technically, under the statute, and Angie, you can take a look at that again, they actually don't have a right to appeal when they're denied. They have a right to come back 2 years later and ask again, but there's no appeal right for a denial of relief or reduction.
I'm not sure what you mean by that. I mean, they can appeal if the ALJ says, I'm not gonna reduce you from a 3 to a 2, they can appeal that to the Court of Appeals.
No.
Or is that not what you're talking about?
No, that's not what we're talking about. What we're talking about is when somebody is already a 3 or a 2 and they appear before the committee for a reassessment to reduce, they are not entitled to an appeal on that. And that's similar to asking for relief. And perhaps another example might be the pardon board. Is there an ability when somebody's asking for relief from the pardon board or something like that, are they allowed to appeal that? I don't believe so. So it would be the same thing, a difference between asking for relief and having a risk level or registration imposed on somebody.
Yeah, I just don't know. I just think it's something that we need to be cognizant of.
Yes.
If that's something that should be in place, and then there are obviously bigger implications if it should be.
Karen.
Well, I was just going to note, and I haven't researched this recently, but I thought that if you don't specify that any administrative decision is directly appealable by writ to the Court of Appeals. So it may just, if you remain silent, increase the number of direct appeals as opposed to maybe sending them first to the ALJ.
So it would a writ of mandamus? Is it a
Writ
writ?
of cert. Writ of cert.
Oh, a writ of cert. Oh, okay.
Okay, Patty.
If there's no, I'm sorry, can I just clarify? If there's no mechanism provided for, then it's a writ of cert to
The Court of Appeals. That's my understanding. Again, I haven't looked recently, but I think that's what they would try, and I think that would probably succeed.
Is that what happens when someone, to what Mark was talking about, if they are petitioning for a downward, a lower risk level, so they're petitioning for relief, sort of, in terms of I want a lower risk level, that's denied, come back 2 years later, there's no appeal process there, right, Mark?
Right, but I think as Karen says, they could always appeal that.
Oh, they could,
To
like
the
technically
courts.
they could if they wanted to. Oh, I see.
They just don't go through the process
Sure.
with the administrative law judge.
Yeah,
Okay.
that was just my point. Silence, I think, doesn't mean there won't be one. It just means they'll all go straight to the Court of Appeals.
Patty,
I'm out of my league here with the legal language. And I don't think anybody's wanting to make it easy to get off registration, but in fact, there are people who, you know, have gone through treatment, they've done everything right, and it can be a motivational thing for them to find work, find housing, marry, and be with their children. And there's a lot of an upside to it for those who have been doing everything we ask of them. And I think especially those who committed their first crimes as juveniles. And I just, whatever the challenges are legally, that's not my forte. You guys can figure it out. But there needs to be an off-ramp because, I mean, I personally know of a man who committed a crime 25 years ago, has never done a thing since. And he can't get work because he's on a registry in another state. But there needs to be a process for those who, you know, have gone through treatment and have abided by everything we've asked of them. And, you know, it probably will be the exceptions, but I think it speaks highly to the hope and the belief that people can turn their lives around and that they will comply, so that there's a possibility that at some point they could move on. That's just I don't know the legal how to get it done, but I think we can build a process for those who deserve the right for it.
are we moving on from the off-ramp discussion? Did we want to cover the juvenile issue a little more, which has probably been the biggest issue covered? If these had been ranked in order, it's probably the one that has engendered the most discussion is juvenile. But
So we talked yesterday during the co-chairs meeting about, and I think I volunteered to do this, but I haven't had since yesterday. But we talked about coming up with some alternative language. Some language eliminating juveniles altogether and some language eliminating the less serious juveniles. And that will be part of the different statutory language that we'll submit to groups next week and then ultimately to this group. So that's kind of where that's at, is a couple of different proposals and kind of see where people are at on those.
Patty.
I just have one question, and it's probably been answered, but what made us have that number of age 10? You know, when the federal law is age 14 thing, why did we jump down to age? That really bothers me that it's even on the record that we would consider a 10-year-old.
I think ours tracks when you can be criminally liable in Minnesota. So it's not a certain age per the registration statute. It's just a certain age under our crimes. Karen's nodding her head. We're under our crimes. You can be liable for a crime. And that's another thing that I forgot to mention to this group is we did there's a law clerk from our office that's going to help kind of do a broad overview of these issues for this group. We've been sending all this stuff out that gets in the weeds a lot, and I'm going to try to get a broad overview of what other states are doing on these main issues. And one of the things we're going to have her chart is what other states are doing age-wise, whether it's all juveniles only of a certain age. if the language, if we were to do the language that limits it's the more serious juvenile offenses, those automatically then would be limited by age, because you can only ask for EJJ, I think, at 15 or older, and adult certification. Or Kate, okay, Kate's shaking her head, but it's gonna limit it certainly, I think, from age 10, but Kate's raising her hand, so maybe she knows more on that.
I have one other comment. We know the research is that when juveniles commit sexual crimes, it's almost always someone that they know, that they're, you know, a neighbor, a relative, or whatever. And yet this is called a predatory offender registry. And that's where I take offense. A 10-year-old is, I just don't think that's fair. And I just want to see, at the very minimum, 10 years old is ridiculous. I honestly, I've seen 10-year-olds do some of the stupidest things because they don't know any better, and we need to teach them, not put them on an offender registry. So you know my shtick. I've said it all along, but for sure, I'm embarrassed that Minnesota would even have it that low. I think that's an absolute that needs to be fixed, and I'll be quiet now. Thanks.
So I'm going to have to ask the chairs here and the body, I guess, as a whole. This time is for discussion among the working group members, but I do see that Kate Richtman, who has quite an experience on juvenile issues, is attending this meeting also and has raised her hand. Are Angie, Sheriff Peck, Stacy, is there an objection to having her speak directly to the questions that Patty and Angie had?
I don't care.
Okay. So Kate, if you can unmute.
So the two questions, and thank you. I don't want to be naughty here. I just want to answer the question. So I put in the chat the registration, or the minimum age of jurisdiction for juvenile court is age 10. And it's interesting because it's not in the juvenile code itself or the delinquency code. It's actually in the child protection code. It's a reverse definition. Our statutes define a child in need of protection or services as any child who commits a delinquent act while under the age of 10. That has been interpreted by case law to be the minimum age of delinquency court jurisdiction. For EJJ, the minimum age minimum age for certification and for designation as an extended jurisdiction juvenile is age 14. I think somebody else also just put that in the chat.
Yeah, Nate Wright put in the chat that children under the age of 14 years are incapable of committing a crime. He quoted Minnesota statute 609-055 subdivision 1.
Right, and then there's actually in 260B, there's 260B.130 is the certification statute. 260B.125 is the certification statute. 0.130 is the EJJ statute, and they also set the minimum age at age 14.
So, and my point, yeah, so I said 15, I think, but my point was, if the language, if we limit it to EJ or adult prosecution, that by nature will limit the age, because now I guess it's 14 and not 15, but that was just what I was trying to say, is it wouldn't be 10. So.
Okay. Representative O'Neill.
So again, something that we really need to look into the database, and maybe the BCA can take a look at this, but of the 38 out of over 18,000 that are currently in the registry that are juveniles, and I realize there were people that started as juveniles and now are adults, I get that, but if we could look at how many of those 38 are EJJ or certified adult, and I'm sure you can't do the whole 18,000. I don't expect that. That's a big ask. But at least with those 38 that are currently there, how many of them are currently, were they EJJ or certified adult? The other thing I think that I don't see on the list yet that might be incredibly helpful is for juveniles to extend the stay of adjudication option from 12 months to 18 months so that they can complete treatment. We've heard multiple times that treatment takes up to 18 months and juveniles don't have the ability to do both. So they run out of their stay and they haven't completed. So they're kind of in a pickle. So I think that if we do nothing else to help juveniles to extend the stay of adjudication from 18 months or from 12 months to 18 months, that is a path I could see easily make it through the legislature. I think it would get at a lot of the issues that we've raised. And then finally, I'd really like to hear from the BCA if they happen to look at those 38 and how many of them are EJJ or certified. And if they're not, can they just let us know a little bit of history? Maybe it's just 1 or 2. I don't know if it's 10. I don't know, but whatever it is that are not either. And what was the situation that placed them on the registry? Because we already have a 12-month. We've extended it from 6 months to 12 months. We could easily do 18. So I think we need that information to move anything forward at the legislature.
And
So-
that request has been made for
Thank
for exactly that information.
So we
Olivia?
actually have pulled data on all of the juveniles that is currently with the chairs. I did not receive final approval to send that out. So if folks are comfortable, I can. We have de-identified and completely taken out any possible data that could link somebody to this spreadsheet. But it does show, it does not go into detail as to the crime statute. It does provide what limited details law enforcement has provided as to the crime. And it does provide information as to the relationship as well as the number of victims on juveniles that are currently on the registry. There is no private data as a part of this, and it has been completely stripped down by Katie and the data practices team, who are also going to delve into which of these individuals have gone into EJJ versus certified adult, et cetera. And so we are currently working on that as best we can, while also trying to maintain the anonymity and privacy of these individuals and not combining details that will show their identities, et cetera. We're happy to send out the spreadsheet as it stands with the information that it has, but we don't currently have that count. In terms of individuals who registered as juveniles and are now adults, that would have to be something that we would chat through internally, because I honestly don't know how we would do that.
And I think that's fine to send that out to the whole group. Stacy and Troy, do you have any issue with that?
I have no issue with it at all. I think it's important that people see what we have, the information we have. Just a quick question for Olivia on the data for the people who are registrants who came in as juveniles. When you say you'll have to talk internally to figure out how to do that, is that like a resources question, or is that whether the data exists question? Because I'm just wondering if it were a Data Practices Act, is that information available, or a Data Practices request, is that information, available? Are you talking resources, or whether it's private or public?
So all of the requests that you send in any format, all fall under the Data Practices Act. So you will get the same response regardless of the format in which it is requested. There is no difference. We respond with the same data that is available under any condition. However, I don't know how we would go through each and every individual and identify who started as a juvenile. Because there are going to be a significant number of people with rather long periods of time and vice versa. And it does not house somebody's entire criminal history. We have also mentioned that there are some data issues with 2014, and that will come up as a part of this as well. We will always do what we can, but there's probably solid combo of data not being there, and honestly, the time that you have before your report is due.
So Representative O'Neill, that request for those 40 has been made to the BCA on how many of those are EJJ and how many of them are certified. So I think, and Stacy requested that as an addendum to the list of 40 that were provided. So whether it's specifically for each case or just as the raw numbers of the 40, this number is EJJ and this number is certified and this number of the 40 are purely juvenile. So that's where it stands at this point. Representative Moeller.
Thanks. Yeah, I think it's really important if we can get into those details for each of those offenses of those 38, which one is EJJ or certified, if that's something that can happen. And honestly, I am somewhat opposed to sending out that spreadsheet until we have that information, because sometimes if we have incomplete information and then people use it to support whatever narrative they want, I do worry about that. So my preference would be that we get it completed first and then share it with everyone.
I have no objection to that. I think that's a valid point for sure.
Yeah, fine with me too.
Okay.
Can I just add, I mean, making sure that, what addressing Patty's concern. So we're looking at, egregious, cases of, egregious conduct, if you will, that would have, warranted EJJ or certified as an adult, and distinguishing and trying to figure out like who are the kids right now that are on the registry, so that we can understand who is being required to register. So I just want to assure Patty that we're trying to understand what that looks like so that we can make a recommendation that is based on at least some sort of data or understanding of how these kids are coming on.
Representative O'Neill.
Thank you. Thank you for saying that, Stacy. I think, it's difficult at the legislature to make decisions when we don't have clear data. It's really difficult. And we absolutely need to know, is there a single person on the entire registry that committed an offense at 10 years old, 11 years old, whatever it is, and ended up on the registry? I don't know if that's ever happened. The potential apparently is there, but understand that the stays of adjudication are used so much now that I don't know if that's a real issue anymore. Maybe it was 10 years ago, 15 years ago, I don't know. But I think what we need to know is right now, as the courts are looking at things and processing through, is that even happening? Is that even a consideration? Has it ever happened in the last 5 years where a 10, 11, 12, 13-year-old ended up on the registry? Because we did change that stay of adjudication from 6 months to 12 months, which should have helped alleviate some of that. So I think we really need to talk about the reality of what's actually happening now And unfortunately, I don't think that, as the BCA has said multiple times, they can tease that out of the data. Which might be another recommendation, which to rebuild the database so that we can look at that sort of thing. The other way you can look at it is say, well, from here forward, this is what we're going to do. And which is why I keep talking about extending the state of adjudication option from 12 months to 18 months so that they can complete sex offender treatment. Because those that quote unquote shouldn't be on the predatory offender registry should be going then through the state of adjudication process, and it shouldn't be an issue at all. And I don't understand, it's one thing to look at what happened in the past when it was only a 6-month stay, or maybe there was a period where there was no stay at all, there was no option, but that's not the reality today. The reality today is we have a 12-month stay. If we extend it to 18 months, that should alleviate the issue of having somebody quote unquote shouldn't be on the registry. So I think we need to talk about what's happening today and not what happened 10, 15 years ago, because we need to deal in the reality of today.
Renee.
Yes, this isn't related to this, but I just want to put this on your radar, Mark. When it's appropriate, I would be really interesting, because it's something that Patty said about the predatory offender and that term. So when it's appropriate, I'd like to get some feedback on, or if there any of the other subgroups have discussed that and what the discussion has been, because methods has not been that focus. So I would just be curious about that when you think it's appropriate.
Yep, and that is one of the issue areas. So,
yeah.
Jim.
I just want to address the comments by Representative O'Neill, which I do respect, but I think I said this earlier. Although the workaround that Hennepin uses, and I think it's been used in some areas of the metro, it's not universally used around the state. So I don't think it's a fix. And I think you would find that some of these kids who are on there are from greater Minnesota. I think there's less likely to use stays of adjudication out that way, and it's more likely that the kids in greater Minnesota are going to be on the registry more so than you would actually find in the metro, which I think might be a surprise to some folks. The other thing is that I'm not specifically certain, and I could stand, I'm open to would be corrected on this, that although I'm supportive of the 18-month stay, I'm not sure that what the treatment periods are, and that treatment could extend beyond 18 months. But I certainly would be open to advocating for more than 18 months if possible.
And just to address one of those issues about use of the stays of adjudication, I believe Karen has provided some data on that. Is going through some of those data information, you did provide numbers on the stays of adjudication used, broken down by judicial districts.
Oh, I think I did. I'd have to go back and pull all the prior charts.
Yeah,
And I don't know if that one was sent out. I would have just sent it to you two.
Yeah, so we'll make sure that that's provided to answer that question. So that'll be in the documents as long as it works out. Janine.
Thanks. Yeah, I'm sort of wondering a little bit about mixed messages to the legislature, and I defer to Representative O'Neill to talk to us about the dynamics there. But if I get the expansion of 18 months, and I appreciate that the rationale is around completion for treatment. but then we're having other conversations that could be perceived that we recognize juveniles as a different type of risk. So if I was a voting uninformed legislator who doesn't get the complexities here, it'd be like a little bit of mixed messages like, oh, wait, we're putting juveniles longer on the registry, but oh, wait, so then we're giving them an off ramp over here. So I just want to be careful again with these intersections. And this may not be a popular idea, and I'm totally fine. I'm just tossing it out there. I think this juvenile issue is really complicated, and it does have intersections in other places. Clearly, we're invested in it. We recognize that there's a problem identification to fix here. I'm wondering if this needs a subgroup somewhere else down the road to really put our arms around juvenile justice in Minnesota as it relates to predatory, that we can really talk about similar of ages that gets on and really what is risk and how long is someone on there and what really are we talking about of what we see in juveniles clinically. Does that really predict what's happening in the future? So it just, I get a little bit nervous. I think these are all super great ideas, but I feel like we may be pulling down pieces and missing the whole picture. If we're going to do it, I think we should really step back and really take time to really look at all of the pieces rather than chip away at the apple. But I'm happy. That's probably not popular, so I recognize that as well.
Representative O'Neill.
Thank you, Mark. So just to Jim's point, I'm in Greater Minnesota, and I know Wright County is a large county. It's close to the metro, but the use of stay of adjudication certainly is not a mystery here. It's used often. And so I appreciate the fact that the courts are going to look at to see how much stays are used. Maybe that's what that is, how much stays are used across the state. And all the legislature can do is offer an opportunity for juvenile justice, I guess is a good way to put it. I think it's kind of up to the County Attorney Association if they want to train their county attorneys how to use it. I don't know how the legislature promotes that. There is a path. It's a little upsetting to know that there's a characterization that Greater Minnesota rural county attorneys don't know enough to use this process. I don't know, but anyways, I just wanted to say that out here in Greater Minnesota, we know about the stay of adjudication very, very well, and it's used very commonly to make sure that, quote unquote, the wrong people are not on the registry.
And I can share the spreadsheet that Karen and Court Services provided on the use of EJJ. It's broken down by judicial districts. So you have the raw numbers there. Did you want me to share that here?
Like to send it out to the group, mean?
Or just take a quick look at it. It'll go to all the group members, but just so you have it right at the time to see the difference in this.
Yeah, I think it's better to send it out to people and let them take a look at it because it's kind of hard to read on here.
Yeah.
And just in the interest of time, because it's 10:34.
Okay. Let's go back to that list then again. Okay, so Jim.
It wasn't my intention to disparage outstate county attorneys. And when I consider in the metro, I do consider Buffalo to be in that area. I'm talking about Nobles County, Clay County, Beltrami County. And it's not that they're not enlightened, it's that there is more of a, and this is just experience and practice, both having been defense attorney and the prosecutor, there's just different philosophies about how to approach these crimes. And I still stand by my statement, and I think it's worth looking at. And I'm not suggesting that Buffalo is in the hinterlands or uninformed.
Well, and I think that we can also, and obviously we need, it sounds like we could use a little more information on this, but we can also use kind of a two-pronged approach and suggest limiting juveniles if that's the group thinks would be, appropriate, and it's our suggest, a certain age and above for juveniles. And that, that stay of adjudication also be extended, so that maybe there's a couple of different ways to address the juvenile issue. And I know I've said this a million times, but I just think that to some extent, this group is going to have to make some recommendations based on policy versus having all the exact data, and maybe that'll help too with getting what we have with the juvenile data, the limited data we have on EJJ and adult prosecution from the BCA. Oh God, I lost my train of thought. I'm getting old. But anyway, I just think from some of it's just going to be from I know, in getting that broad overview of what other states are doing. So I think that will all help us, at least from a policy standpoint, where we don't maybe have all the data, and if it's going to years and other work groups and whatever to get that information. From a policy standpoint, I think we can look at that information and at least make an informed policy recommendation, if that's something the group wants to do.
Okay. So we have that segue. I think both Patty and Renee mentioned this, and that was the term predatory offender. Renee.
Oh, yeah, thank you. I actually wanted to comment on the 12 months to 18 months. So some years ago, I served as a group on what's called the Correctional Program Checklist or Assessment, where a team of individuals would go out and assess programs. And this comes out of the University of Cincinnati and the research that they did. The rule of thumb with treatment length there, when we went to juvenile programs, was 12 months. With that being said, though, we know because of brain development and kids themselves, it can take up to that 18 months specifically. So I guess I would propose to 24 months, because when they're done with treatment, you want to make sure that they're following what is typically called a maintenance plan or a safety plan thereafter. So just a suggestion, but in the work that I did, that's what we knew from the research coming out of the University of Cincinnati.
And then did you want to address the term predatory offender?
Yeah, as I commented before, I line up with Patty. I find that word predatory offender just real offensive. And again, we haven't really had this discussion in the methods subgroup, so wondering it's here. So I'm anticipating that some of the other subgroups, or one of them, has talked about this and what that discussion has been.
Well, so I think the change was made when non-sex offenses were added in there. It was no longer the sex offender registry. So I think that's where that term came from. So I don't know if there's a way to say offender registry. I don't know if there's a way to describe it. If you guys have ideas for a way to describe it in a better way than sex offender or predatory offender, or just say offender registry. I don't know. I don't think we have any other offender registries in the state. What do people think about that?
It's an interesting thing from that historical point, is that there was concern in the legislature about using the term sex offender for those who were not convicted of sex offenses. So they thought that predatory offender was a better name. What we've found around the country now, including even the federal legislation, is that they use this term sex offender, and it doesn't matter whether it's somebody who's committed a sex offense or not. Courts have determined around the country that the term sex offender can apply to anybody on a registry, whether sexual offending was involved or not.
But I just feel like you're gonna have a whole group of people saying, I'm not a sex offender. Why am I on a sex offender registry? I assaulted my wife, or I committed false imprisonment, or whatever reason they're on there that's sexual. So you know, it's kind of like you have the same issue if you say sex offender registry. And, you know, I don't know if there's a way to not say either, if that makes sense. Yeah, you're right. States generally say sex offender registry, but I think that's part of the issue is people who aren't sex offenders don't like to be called sex offenders, and nobody apparently likes to be called their predatory offenders. So I don't know.
Patty.
Quite sure that on a federal level, the predatory offender registry came from the Adam Walsh Act. And when we first created sex offender registry in Minnesota, it was for sexual offenses. And although people may challenge that they're on a registry if they didn't commit a sexual offense, I would challenge that as well. But other people who are sex offenders may have only victimized one or two people. They're not predators. So I really think language needs to be thoughtful. And I don't like the term predatory because I just know that there are many people who offend against someone known to them, maybe only once or twice, but they're not stalking and hiding behind the bushes, and they're not, you know, what I'm talking about is you have to deal with public perception, and predatory offender connotes a really bigger, more scary, dangerous, stranger type person. And I really think the language needs to be addressed, especially if we're going to put any youth under, youth juveniles on this. I just think that kids don't belong on a predatory offender registry. It works against everything that I believe in.
Katie.
Going to back up to Andrew asking about just calling it an offender registry and such. Just want to make everybody aware that there are certain states that off the top of my head I can think of for sure. Illinois and Florida, they have drug registries, violent offender registries. One of the Dakotas registers for child abuse. We often get paperwork, court documents saying, does this person have to register? And it's a child abuse, a straight child abuse case, no sex crimes committed in it. So just being very careful. And then I'm just reading through some of the chat here, and I'm not sure who everybody is on the chat, but we'll get offenders in the lobby too, and they are adamant that they are not sex offenders. These are most likely the people that have false imprisonment situations, and so they make it very clear that they are not a sex offender. The FBI lists everybody that gets sent to NCIC as a sex offender. So I'm not sure, Patty mentioned possibly coming out of the Adam Walsh Act, the term predatory offender, and I'm not certain if that's where the legislature pulled that name back when they changed it after Katie's law or not. But I know the majority of states still call them a sex offender registry or an offender registry, violent offender registry. And like I said, then there's also the drug offender registry. So just a little bit of food for thought on that one.
Mm-hmm. Nicole.
Thank you. Yeah, I do think it's confusing because I think, there's the public perception that the registry is a sex offender registry. And so I don't know what the solution is, but it can be very confusing, and especially when for most states and for most people's understanding, registries are for sex offenders. So, and I do agree that our kids should not be in a predatory offender registry.
Okay. We've got other areas here. Was there any? Those that haven't been bold yet. Representative Moeller.
Thanks. Yeah, I know Representative O'Neill mentioned this a couple of times with respect to data. And I think there's a bullet point here, original purpose of registration as exclusively a law enforcement investigation tool. And I think it would be really useful if the group wants to think about making a recommendation to the legislature to either somehow change the database currently so that we can extract this kind of information, or try to get this data some other way and provide resources for that in the future. But I think data collection, oh, there you have it. Sorry, I didn't see it on there, Mark, is an important consideration. And then just one other question I have, and it relates back to the false imprisonment bullet point. If the group makes that recommendation, then I'm curious what happens to those currently on the registry for false imprisonment that didn't come out of a sex crime and it's the same set of circumstances situation. I know, Stacy, I think you're the one who's talked about retroactivity in the past. And so I just want to flag that if there's going to be any kind of recommendation about what we do to folks who are on the registry for something we might be removing future people off the registry for, and maybe the off-ramp takes care of that too.
Okay, Patty.
Thank you. I would totally agree. That's what I was going to say. I think one of the things that an outcome that could come from all of this discussion is, what is it that we need to know that we can't know right now? The BCA was created to keep current addresses and to know where these people are. But what else do we want to know? Is this registry even working? Does it make communities safer? Is it protection? I think we need to list those. And I think that we need to ask for, a database that can deliver some of that more information, so that down the road that we know what part's working, we know what we are missing, and that we can start gathering. And it won't be retroactive. Probably we might have to start today of collecting some things that we hadn't before, and 5 years from now we'll be able to judge. But we have to start collecting the information that we're wanting now. And it's not fair to ask the BCA to do that with what they currently have. That their mandate was different than what we're looking at now. But I really think it opens up the discussion of what part of this is working and what part is not. And one last thing is, like, I hear Representative O'Neill saying, that, there haven't been 10-year-olds put on, but I think then we need to take that off the record, that they can't be. I just think that we can't work around these laws if we need to change them so that, in fact, it's not the way we want our state to function. So that's just my added 2 cents. But I do really appreciate the request for data, because then we can make intelligent, less emotional, but factual based decisions going forward. Thank you.
So we are approaching the last 10 minutes here. So that's when we do open it up for public comments. So if anybody in the public at this hearing wants to speak, please raise your hand and we'll get you into the queue on this. But first, Stacy, did you have something to say? Or okay. So next person is Kate Rickman. Okay, there you are.
Thank you, and I will lower my hand now. So I am speaking on behalf of the Juvenile Justice Advisory Committee, also known as JJAC, and I hope that you can hear me. I'm also speaking as a former prosecutor. The Juvenile Justice Advisory Committee's position on predatory offender registration as it applies to juveniles or to youth is that Minnesota's laws should be amended so that the registration laws don't apply to most, if not all, juveniles. And so that is our position. We have published that, and I'm speaking on behalf of JJAC, strongly supporting eliminating the need for registration for children. Or if there's a decision to make about which children to be very limited. I'm also speaking as a prosecutor, former prosecutor. I was 25 plus years with the Ramsey County Attorney's Office as the director of the juvenile division. And during that time, I was one of 2 attorneys who were responsible for reviewing all of the crim sex cases that came in to our office. And as the director of the division, I was also responsible for overseeing and supervising the prosecution of any case that got charged. Based on my experience, both as a prosecutor and quite frankly, as a member of JJAC, I would like to share that I don't believe that public safety is served by requiring youth to register. Current research on the value of requiring children to register as predatory offenders really actually supports eliminating that mandatory registration for youth. I've found no published studies that conclude public safety is enhanced by requiring youth to register. And in fact, the opposite is true. And as a practical matter, I've never seen that having hundreds, if not thousands of children on the registry enhances law enforcement's ability to combat sexual offenses. I also want to echo what Ms. Wetterling said earlier, and that is that registration really is contrary to the rehabilitative purposes of juvenile justice system. It's been said several times during this meeting that youth as young as 10 can be on that registry. What hasn't been said, or they can at least be subject to the registration requirement, but what hasn't been said, and I don't know if it's been discussed before because I unfortunately haven't been able to be part of your meetings before, but there's research that shows that youth required to register are at greater risk for suicidal thoughts, alienation from peers, school problems, and housing instability. And the housing instability I want to echo or want to emphasize is, remember, children they're not the ones moving. They're subject to wherever their parent or caregiver lives. The collateral consequences that follow youth can prevent them from obtaining employment, being admitted into colleges or universities, and from being qualified to serve in the armed forces. And I think it's really hard to believe, and it's actually been said already this morning by Ms. Wetterling, that I find it really hard to believe that when this law was passed, that the legislature thought that children as young as 10 should apply to them. And as you've already discussed, for many years, some juvenile court prosecutors, defense attorneys, and judges have recognized that mandatory predatory offender registration doesn't fit with the juvenile court cases that they're seeing or the purpose of juvenile court. And so they found ways to work around it. One of them is the stay of adjudication. But as Jim Fleming said, it's not consistently applied across the state. It's also, I want to speak to the idea of extending it for 18 months doesn't resolve that problem. That there are some counties in which a child will receive a stay of adjudication, and there are some counties where a child will never receive a stay of adjudication, so unfairly impacting them. But it also, seems to be a misconception that a stay of adjudication can only come from the prosecution's discretion to offer one. That is not true. Under Minnesota law, a judge has the ability to stay adjudication over a prosecutor's objection, and that decision will be reversed only if there's a clear abuse of the judge's discretion, which is hardly ever going to be found. So that means that when you change the stay of adjudication statute, you change it for all offenses that apply to all juveniles within juvenile court. And so it is possible, and in fact, I have seen this happen many times. A judge will stay adjudication on a very serious offense. So for example, an aggravated robbery. Well, if there's a stay of adjudication on that case, the child isn't barred from possessing a gun because there isn't an adjudication of a crime of violence. So there are times when prosecutors really vehemently disagree with a stay of adjudication, and it is nevertheless granted. And so that's, I think, from a prosecutor standpoint, very problematic. I also then I don't want to take too much time because I'm sure there are other people who want to comment, but I would encourage you to look at the purpose statement found in the juvenile court code, which is 260B.001 subdivision 2. And it really focuses on the need not just to promote public safety and reduce juvenile delinquency by maintaining the integrity of the substantive law, but it also talks about developing individual responsibility, and it talks about rehabilitation. And when you label children as young as 10, 11, 12, 13, all the way up to 17, 18, or 17, you really have an impact on how they view themselves. And so I just caution the solutions that have been proposed in terms of, well, we can just stay the period of adjudication. That really isn't the workaround that I think needs to happen. I think we need to say very clearly as a state, children don't belong on the registry. And I thank you for the opportunity for making these comments.
Jane Schmidt.
Good morning. Not sure if you want my camera on or off, but anyhow, I am a probation officer out of Brown County, which is in southern Minnesota. And I have supervised juvenile probation for 14 years. Prior to that, I was a licensed social worker for 15 years, all working with juveniles during that time. I have chaired the MCA, which is Minnesota Corrections Association Juvenile Justice Advisory Group, for 5 years. I'm the incoming president for MCA, and I am also an ex officio member of JJAC. So I agree wholeheartedly with what Kate says, but I can tell you, as somebody who directly supervises youth who are on the registry or subject to the registry, it happens. I have a 13-year-old who's on lifetime registry, currently 16 years of age. Stays of adjudications aren't always granted. I also have an individual who's on the registry under a false imprisonment for a domestic assault that occurred. The biggest thing that happens with these kids is the collateral consequences that haunts them for an extraordinary amount of time. They're prevented from getting jobs, living arrangements. If they wanted to go into a nursing home because they got in a horrible accident, they wouldn't be allowed. Treatment does often take longer than the 12-month period. Biggest thing I see for kids is difficulty with the failure to register, and it's simply because they're kids and they don't always take into consideration all the requirements involved in POR. I have kids that have called me back 5 years after I've been supervising to ask me how to go about something with the registry, or why can't they get a job because of this. I would also like to say that in my 14 years of working with kids in juvenile probation, I've not had a single kid reoffend, ever, despite if they were on the registry for 10 years or lifetime, because I have some that are probably 29 years of age right now. I'd highly, highly recommend that we look at this in a serious nature, that it causes far more good than harm. The information we can get from a DNA sample certainly gives us quite a bit to go off of. I've had that happen where kids give DNA samples just based on a felony or even a non-felony conviction, but related out of same set of circumstances. And we still can catch them on an entirely different crime set. But I think it's very important to take perspective of somebody that's worked with these kids directly, worked with their families, and had the impact that it takes when they're really not fully developed. At age 13, I'm not sure how you can say this kid is a risk for the rest of their lives. So thank you for your time.
Okay, thank you. We are at the end of our time, but I think you can see that calendar that we didn't get to. Is there any action on future dates that needs to be done today? Next week, we do have the regular subgroup meetings on Monday and Tuesday. And then the following week is scheduled for Wednesday before Thanksgiving. There has been a proposal to move it to Tuesday or something else. Anything from the chairs on this, on the calendar? Can it be addressed later?
I think we were just saying that probably we should move the November 24th date up if that worked for people, or cancel it, but probably move it up just because we're getting close to the end on things. And then I think we had decided that with the other dates, that we would kind of decide as we go along whether to add those in or not. If we do, we would do the full group dates on the 1st and the 8th, I think. Stacy and Troy, is that what we were talking about?
I think that you said the 1st and the 15th, and that you didn't want November 24th because of the holiday. But obviously we will meet whenever the chairs would like to.
I think we were going to decide later whether to add 8th in there, to do it weekly versus every other week, but we can just worry about the 24th right now. Would it just, I don't know if we can, if there's a way to do a show of hands or anything, but do people in general think it'd be better to do Tuesday than the day before Thanksgiving?
Those in favor, if you raise your hands.
So raising hand means you favor Tuesday, the 23rd.
Tuesday,
Right.
the 23rd. Okay, and then lower your hand there, and then those who are opposed to moving it, raise your hand. So
So it looks
I
like it
have-
works best for most people to move it.
yeah. So I have one,
Okay.
Patty, you want to keep it on the Wednesday? Oh, sorry.
I don't think I can make that meeting on Tuesday.
Okay.
Yeah.
Okay. We'll have the chairs make that decision and change the meeting or leave it.
Well,
later,
I think we should
but-
change it just because most people,
Okay.
it works better for Tuesday.
Okay.
But we can also do the December 1st and or the 8th. So we'll come back with a proposal on whether to add the additional December 1 and 8.
Yep. Okay, that wraps it up. Any last word, Olivia? Nope. Or the chairs, any last word? Oh, Representative O'Neill.
Sorry, just quickly, I'm not available on December 15th. So I don't know if you're going to meet and discuss the report, but I only take 1 week vacation, and usually it's shrunk, and that it's the only day I'm taking off for like an entire year, so.
Okay, and we don't have those dates set yet, so we'll get back to you on anything after next, or Tuesday, the 23rd for the full group.
Okay, thank you.
Yeah.
But thanks for
Okay.
letting us know that, because I think it would be helpful to have you, obviously, if we're discussing the report.
Anything else? Otherwise, we'll wrap this up. 4 minutes overtime, but not too bad.
Good job.
Okay,
Thanks, everyone.
thank you, everyone.
Thank you.